that the phone, the Verizon phone, was hitting off a tower very close to their residence in Glendale, miles away from the shooting, at 10:51 and 11:04. Those are the relevant times we're asking Your Honor to look at with respect to this motion. The shootings were miles away. This is information that would provide an alibi for the defendant. Clearly exculpatory information that was known to the state. But in terms of corroborating the defendant's use of this phone, his primary use of this phone when he is with his fiancée, when he is not working, when they are together 24/7, there was additional information that was known to the state. First, there was the pawn slip. The court saw that appended to our motion. That was actually the pawn slip from August 30th, 2015, that Sunday afternoon at 5:31 p.m. Well, as the court, I'm sure, has noted, the phone number associated with it with Mr. Merritt is not the Obama phone. It's the Verizon phone. Yet again, objective evidence far predating the allegations against the defendant, far before he became a blip on the radar to law enforcement, that suggested that the Verizon phone was his primary phone. Additional evidence can be gleaned through his employment records. On September 18th, again, well before he became a suspect in this investigation, before this case went to the grand jury, law enforcement uncovered employment records created long before he was a suspect. That's referenced at page 13 of our motion. Once again, the Verizon number is the primary number that he uses. And this is all, again, clearly exculpatory, and all of this was known to the state at the time it presented this case to the grand jury. It all ties in to this document, Your Honor. And the state knew it. And I want to say for the record, perhaps a little bit off script, by no means am I attributing any bad faith to these prosecutors. I'm not attributing bad faith to the county attorney's office or the Department of Public Safety. This is a massive investigation, and things happened very, very fast. There was a mountain of information to go through, and this was clearly in their possession. I'm not saying it's intentional. I'm not saying it's deliberate, but the reality is it still doesn't mitigate the fact that the defendant's rights to due process were clearly violated by their failing to present this information. As we now turn to count 4, I'm sorry, I said count 4. It should be incident number 4. And let me clarify. We're referring to the shooting that occurred, according to the indictment, sometime between August 22nd and August 27th. And specifically, the grand jury transcript only refers to August 27th between the hours of 5 and 5:55 a.m. And just to set the backdrop, the victim in this case, he lives in North Scottsdale. I wouldn't say he lives up near the Boulders, but he is well north of Shea. And I think it's important not to out that gentleman, but to give the court some context of the driving time that it would take for him to get to the airport. What the state knew about that incident is, and I should say from an interview they conducted with his employer on September 21st, Mr. Merritt was at work by 6 a.m. in Sun City, specifically 99th Avenue in Bell. And there's another exhibit in our motion that puts him in that vicinity, 99th Avenue in Bell, at 6:24 a.m. Now, the state's going to say, well, that doesn't exclude him between 5 and 5:55. But logistically speaking, when you're coming from 67th and Myrtle, you are not going to intersect the victim's route, which we logically believe to be the 101 to the 51 into the west side of the airport, in that he was flying out of Terminal 2. It's just absolutely impossible for that to happen. Unless, of course, the defendant was somehow late to work, he didn't show up at work, but the state had no evidence to suggest that was the case. And as the court read in the response and the reply, they in fact later learned that information, but clearly we need to confine ourselves to matters known as of September 24th, and the court, I believe, is nodding in agreement with that principle. So effectively, this is something that is clearly exculpatory, clearly favorable to the defendant, but what the state does is they water it down at the grand jury. They say, well, we can't really prove it one way or the other. But it's clearly exculpatory when at 6:24 in the morning, he's at 99th Avenue in Bell, and this shooting occurs a short time prior. There's no way he could be there. There was no evidence that he was late to work. Again, it's clearly exculpatory information. The court knows there's another document appended to our motion. It's a similar reconstruction by the FBI showing exactly what I'm talking about. Moving on to the second issue, the statements of the defendant's fiancée. And I think it would be fair to say, for the record, that when she was interviewed by law enforcement a very short time after the defendant's arrest, she provided him an alibi. She said, we're together all the time, we're always together on weekends, unless he's working. Yeah, he worked Labor Day, but August 29th and 30th, we were together. And I believe it was appended to our motion, a transcript of that interview was provided to the court, and we also hand-delivered a DVD of the video of that interview. Because when I reviewed the video again as part of the reply, it was so powerful and it speaks in ways that a black and white transcript can't. I'm going to ask the court to admit that as Exhibit 1 to today's hearing, and my hope is that the court has looked at it, but the reality is it underscores our point that the fiancée was a witness. She was never, ever, ever a suspect. And the transcript citations in her reply make that abundantly clear. The detectives told her as much. But when they provided that alibi, they were not satisfied. They challenged her. They berated her. They browbeat her. They even lied to her and said, well, there's a video of the shooting, and they challenged her, as to the fact that she was with him all the time. That must be you. She said, show me the video. They scurried away from that because the reality is there is no video. They lied to her. They lied to her to try to get her to abandon the alibi that she gave Mr. Merritt. And as the court saw, she was brought to tears on numerous occasions. And ultimately, the tipping point was when they threatened her with domestic terrorism. And that was pretty far into the interview, Your Honor. As you watched the DVD, you realize it didn't happen in the first 5 or 10 minutes. She was steadfast. She was adamant that she was with him and that he could not have perpetrated the shootings. Again, that's clearly exculpatory evidence. But it was only when they made that threat to her, although she was only a witness supposedly, did she relent and did she change her story. The court knows she's a young woman with 2 small children. She was threatened from being away from her family, the children, that the whole family would be charged. There was absolutely no evidence to support that. It was a bullying tactic and an offensive one. Now, the state, in their response to this assertion, claims that, well, law enforcement can use a little bit of trickery. Then admittedly they can. I think the case law is clear, but only when it comes to a suspect. There is no case law that I located that indicates that the police can lie to a witness to get them to change a story against a defendant or for a defendant. And that's exactly what happened here. The cases that the state cites are entirely distinguishable. And as I indicated in my reply, I would respectfully submit that if it were a defendant who was treated that way by law enforcement, lied to, badgered, bullied, browbeat, and threatened with domestic terrorism charges, and the court heard that in the context of a hearing concerning the voluntariness of those statements, I think the court would take pause. And I think the court might well exclude those statements. But that's a very different standard when it comes to a defendant. In the instance I cited, this is a witness. She had no skin in the game other than providing information, frankly, that did not jive with the theory of the case that law enforcement had. And it was purely for that reason that they did what they did. So how does this fall into the motion to remand? Well, it's quite simple that law enforcement kind of glossed over in the most favorable of ways to their case. They said, well, yeah, she provided an alibi and she changed her mind. But there's a whole backstory. And it's not just that the devil is in the details. This is a situation where the state went from A to Z. But it's everything from B to Y in the middle that makes all the difference. It's how they got there, the tactics, the techniques they used, that clearly should not and could not be condoned by this court or any other appellate court in this state or this country. So we believe that the presentation with respect to the alibi witness recanting, that yet again violated Mr. Merritt's right to due process. We have no issue with the truth coming out. We want everything to be heard. But what the state did, they cut and paste things, whether it's the cell tower information that was clearly known to them, the defendant's use of the Verizon phone at the time of the offenses. This was all known to the state. Likewise with the alibi. This all should have been presented. The big picture needs to be presented, not just what the state wanted a grand jury to hear. And our position is that it constituted a violation of Mr. Merritt's right to due process, and for any and all of these reasons, a remand is warranted.
Thank you. Judge, first, in regards to what I believe we refer to as Incident 4, specifically the shooting of Alfred Hackbarth's BMW, nowhere in the presentation to the grand jury does the state ever, despite what Mr. Lamb has indicated, indicate that the shooting occurred in the morning of 8/27. The specific charge is a date range of 8/22 to 8/27. Nowhere in the presentation at any point does the state indicate that the shooting of Alfred Hackbarth's tire occurred in his route to the airport in the morning of 8/27. In fact, despite what Mr. Lamb has indicated, the state did present to the grand jury specifically that the work records that were available at the time indicated that he was at 99th Avenue and Bell. We provided at least insofar as there needs to be an alibi on the morning of 8/27, we provided the information to the grand jury that he was most likely at 99th and Bell at the work site, which is corroborated by the cell phone records. Specifically, in terms of what was presented in relation to that incident, Judge, the information presented to the grand jury was that as of 8/22, specifically August 22nd, the defendant, I don't believe this is in dispute, the defendant did have the gun in question out of the pawn shop, so that was the operating fact for that date range. It is not yet clear, strike that. We did not present any information specific to the grand jury that pinpointed a specific time that that shooting occurred. The information provided to Department of Public Safety by this particular victim was he never heard a rattle, never heard a gunshot, didn't know. He couldn't say it was on the route to the airport. He simply didn't know. So there's certainly nothing presented to the grand jury that was in any way misleading or unfair. In fact, it was exceedingly fair because we did provide information that the defendant was, in fact, most likely at the work site on the morning of August 27th. In regards to this idea, Judge, that the specific phone 480-532-3973 provides an alibi, what Mr. Lamb has done both in his initial motion for remand as well as his reply, he indicates that this is exculpatory evidence. The state submits, Judge, that this phone, as indicated by the interview of Adina to the Department of Public Safety, this was a house phone. This phone can be equated and is akin to a hard line at a house. The information that was specifically provided in both the motion and the response, Judge, was that all of the information contained in the 480-532 number supports the fact that Dina was the principal user of that phone. She corroborated the fact that she's the principal user of that phone, and we can see by the contacts list and all the information contained in the phone, as well as incoming and outgoing text messages. And I would note for the court that there is clear text messages or contact between the, as Mr. Lamb referred to it, the Obama phone and the 480 phone. So there's contact going on between the two. Judge, in regards to the specific conduct of the Department of Public Safety, the state doesn't dispute that tactics were used to try and get information from Dina in this case. But I think it's important and critical the court look at what she initially said. Mr. Lamb would have you believe that she came out and said, no, on 8/29, Leslie Merritt was with me at this place, and this is what we did during this period. That's not all that happened. Her initial response, and this is long before any reference to a video that the state admits doesn't exist, or allegations of domestic terrorism, she said, he's most likely with me. In that's the context of that, again, before any reference to domestic terrorism or video, she says, at one point, I just don't remember. He most likely would be with me because we are with each other on the weekends. That was the information presented to the court, to the grand jury, that initially she said they were together. In fact, it was more than fair. What was presented to the grand jury wasn't that she said most likely, but that she initially said that they were together. And I think it's important that the court looks at the cell phone records and notes, as is contained within the motions, that there is specific contact between the Leslie Merritt's phone and Dina's phone on 8/29, which would indicate that they were not together. We also know that they weren't specifically together on 8/30, August 30th, when the gun was in fact pawned. That's not in dispute. So this idea that they were together 24/7 is verifiably false, and so the information presented in that respect to the grand jury was in no way misleading and clearly would not rise to the level of exculpatory. Judge, I would note that, and I understand Mr. Lamb talked at length about the tactics used by law enforcement. Obviously, law enforcement used the tactics they did to try and get information from a witness. It's very clear from that interview. She was considered a witness. Her child was there at one point. She was considered a witness. There is nothing, Mr. Lamb says, well, there's no case law that says they can do it. There's no case law that says they can't engage in those specific techniques. What I would say is that the information that was provided Okay. Judge, if, as Mr. Lamb speculates, the same sort of conduct were to occur with a defendant, the recourse is not remand. The recourse is suppression. Having that information does not require that the case be remanded. That is not, in fact, exculpatory information. That is information that Mr. Lamb can use to denigrate Department of Public Safety in the course of the trial, or to establish through examination of Dina why she may have initially said, why she said what she did. And that we will explain. And that is the proper recourse, and that is the proper avenue for using that information. And may I have a moment? That's all, Your Honor.
Mr. Lamb? Judge, if I may, I'm going to mirror Mr. Leiter's response somewhat chronologically.
Okay.
When we talk about the fourth shooting occurring on August 27, Mr. Leiter says, no, it's just a broad range. It could have been anywhere between the 22nd and the 27th, and we don't disagree. The 22nd is when the gun came out of pawn, and the 27th is when the victim went to the airport in the very early morning hours and parked his car. I don't think that's disputed. But here's the thing, Judge. There is absolutely nothing in the grand jury transcript that talks about August 23rd, August 24th, August 25th, or August 26th, and for that matter, August 22nd. No evidence whatsoever. It's very clear in the transcript. All we talk about is August 27th. So what they did is put a broad date range in there because they really don't know when this happened. And you'll pardon the double entendre, particularly in the context of this case, but they basically fired a shotgun at the side of the barn. And that's how they got the indictment for this count. I would differ with Mr. Leiter in terms of what was or wasn't presented to the grand jury about Mr. Merritt being at work, and I'd simply just urge the court to let the transcript speak for itself. Moving to the Verizon phone, the 480 number, yes, the fiance was the principal user of the phone when the defendant was at work. The weekends, then they're together. When these counts occurred, allegedly, they're together. They're joint users. And there's somewhat of a red herring, if you would, that the state threw out there about text messages between the phones. Well, it's not during these times. The first messages occur between the two phones very late on Saturday night. I'm not going to get into matters outside the record, but I'll just generally proffer that Mr. Merritt was at home, he stayed with the baby, Miss Beyonce went out with her sister to pick up their stepfather. That's when the two of them are communicating. It starts somewhere in the area of 11:30, 11:45 at night. So who cares? It's after the shooting. It means absolutely nothing. I guess the state's trying to say that Ms. Salcedo wasn't razor sharp. There I go. I said her name. I didn't mean to. Nonetheless, she wasn't razor sharp. But, Judge, let me ask you, and I ask you rhetorically with the utmost respect to the court, tell me what you were doing 3 Saturdays ago between 10 and 11 a.m. Were you with your wife? And you may say, and I'm not delving into your personal business, but yeah, my wife and I are together on Saturday mornings. We typically do X, Y, Z. This is what we do. Can I tell you if I had eggs for breakfast or if I had French toast? No, because it's not a significant event. There's not a critical benchmark. But if you say, yeah, sure, we were in San Diego for the weekend, absolutely, I can tell you what it was. So there was nothing really significant going on. It wasn't as though there was a benchmark for her to remember, but the state seems to think that this is somehow nefarious. And I'll leave that to the court. With respect to the interrogation tactics, and I'm using the term interrogation because that wasn't a witness statement, that was an interrogation. And as far as the case law, Judge, the video speaks for itself. I contemplated playing it today, at least snippets of it, but the court's seen it. I don't think I need to broadcast it. I don't think the sinister nature of it needs to be shared any further. And while Mr. Leiter responded with the recourse being suppression, respectfully, I think the state misunderstands what I'm saying. Recourse is dependent on what the forum is. If it is a defendant's statements that are involuntarily made and they're the product of force, threats, or coercion, which arguably the fiance's statements were in recanting the alibi, all three, and it's a defendant, then we have suppression. But when the evidence of the statement is being introduced in a grand jury proceeding, suppression isn't available. We don't get to suppress her statements, because the real issue is not whether the statements were made on a voluntary basis, whether there was Miranda, whether there was promises, threats, force, or coercion, but it's whether Mr. Merritt's due process rights were violated. And the remedy there is remand. And as I said earlier, basically they went from A to Z. They left out everything in the middle. That everything in the middle, that's the tactics that they used. And I think the grand jury was entitled to know that as a matter of due process. How did they get her to change her story? By making her cry, by threatening her, and then threatening her ultimately with domestic terrorism, and her family at that. That is material, that is significant. That deprived the grand jury of the full and complete picture, not just what the state wanted them to hear. So once again, we're going to ask you to remand this case for a new probable cause determination. We want everything to come out. Thank you. Does the court have any questions?
I do. Mr. Leiter, I want to ask, the probable cause basis of these counts is the ballistic evidence that was presented?
That's correct, Judge. Let me
go ahead.
Let me say that is the crux of the probable cause. The state would profit that there is additional circumstantial evidence beyond just the ballistics, but yes.
And in a grand jury setting, we don't get into the kind of evidence. I'm with you there, but just on the term, the concept of clearly exculpatory. Then it says, another case, I didn't do it, I didn't do it, I didn't do it. Okay, I did it. Would you be obliged to tell the grand jurors that he denied it and then he admitted it, or is it okay to just say he admitted it?
Judge, as a practice, I would give the grand jury, I don't think we need to. I don't think that's clearly exculpatory evidence, initial denial. But I think if we are going to bring out at least part of it, I think we should bring out the entire part of it. And the state would submit that what we did was bring out that she initially said they were together and then subsequently said she's changed her story. And I think that is what the critical analysis is for determining whether or not it's exculpatory. Bring out that information.
And Mr. Lamb, the same question. What obligation do you think the state has when you have my hypothetical, a suspect says, I didn't do it. Okay, I did it. What are they obliged to present in the grand jury?
In response to the court's question, clearly we're not dealing with a suspect, we're dealing with a witness. But if you're asking me in the theoretical, I believe they have not just a choice, but an absolute obligation to present the exculpatory and the inculpatory. And if there is a intervening circumstance that is extraordinary, and I submit that it was extraordinary what occurred here over the course of the very lengthy interview and the conduct that we've talked about at length, I think it's incumbent upon the state in the preservation and maintenance of the defendant's due process rights to say what caused a suspect to change from I didn't do it to okay, I did it, if there was some force, threats, coercion.
Well, and who discerns that?
I think it's a matter of fact for the grand jury to determine.
Well, then do they play the whole tape of the conversation?
Under Bashir, they need to get a fair and accurate representation of what it is. And summaries are acceptable so long as they are fair and accurate. I would submit that what was presented was by no means complete, fair, nor accurate.
Well, in a grand jury setting where hearsay is allowed, how are you protected from a officer who's honestly giving a version that's favorable to the state as if the battle hymn of the Republic was playing behind it, and the contrary version as if it's a Brussels sprouts recipe?
Well, I don't like Brussels sprouts. That's the first thing.
Why I picked that one.
Exactly. Well, quite simply, the recourse is exactly what we're doing today, to challenge the grand jury proceedings, to show the due process violations, to show the stilted and slanted presentation, and to have Your Honor make a finding that the defendant's rights to due process were violated by not just an incomplete, but a presentation that was incomplete to the point of being misleading. You can't take letters A and Z and say, this is an alphabet, just because you've got the bookends. And that's all they did.
Well, wasn't the presentation somewhat of a apples and oranges? You have the apples of the ballistic evidence and the oranges of territorial areas and alibi.
No, we certainly had the apples, but I think maybe we got a little bit of orange peel. That's about it. We didn't get to the whole orange. Because, again, just because you have orange peel isn't indicative that you have a whole orange there. You may have the remnants of it, but you can't make orange juice from orange peel, and it's that juice, that pulp, if you would, if you'll forgive me, that is the preservation of the defendant's right to due process. So I think, again, it wasn't just incomplete. It was incomplete to the point of being misleading to the grand jurors as to how the fiancé went from, I was with him all the time, he didn't do it, to, I don't know what the hell you're talking about. And Judge, just to point out for the record, the trigger for her to change her tune was that threat of domestic terrorism. If you watch it, you'll see that's when she did a 180, when they threatened her and her family with domestic terrorism. That was clearly, the trigger point in all this.
It could have been her road to Damascus, too. Her road to Damascus. That's something that a trial juror can discern, don't you think?
Well, I would disagree, because when we're trying to present, a fair and impartial proceeding, I hate to use the ham sandwich reference, but that's what happens. When the grand jury is told only what the state wants them to hear, only what's favorable to their case. That's the problem that we have. If this were a preliminary hearing, and that's something I would certainly welcome in this case, with Your Honor presiding to hear all the evidence and all the witnesses, of course that would come in. And I would almost, query to the court, if I may, that if you were presiding over a preliminary hearing, that would be the type of evidence that you would allow in. In fact, you would insist on hearing that type of evidence. What caused a dramatic shift and a diametric change in a crucial witness's testimony who's providing an exculpatory alibi?
Thank you, Mr. Lamb. Thank you. To that last point, the grand jury is not me. It's a body independent of court and the prosecutor. They are to determine only probable cause, whether a crime was probably committed and probably by the person suspected. In a trial setting, we will tell the jurors that an expert witness should be treated like any other witness. Their opinion can be accepted in whole or in part. We will tell a trial jury that they can believe everything a witness tells them, part of what a witness tells them, or none of what a witness tells them. A grand jury setting allows for hearsay testimony, and so therefore the credibility function for a grand jury is not the same as the credibility function of a trial jury. Short of requiring the grand jury to listen to the entirety of any tape, watch the entirety of any tape, it does allow for summary analysis, and it's never going to be the same analysis as done by defense counsel. So having read the transcript, looking at all the exhibits, the court finds that the differences between the approaches of counsel is better set in a trial setting than in a grand jury setting. So the motion for remand is denied. We have various motions for disclosure. Ms. Losico and Mr. Lamb. Talk about it conceptually first. Because some of the disclosure request deals with events other than those charged in the indictment. Mr. Lamb, I'm another hypothetical. I'm charged with stealing Humvee hubcaps. And I tell you, my defense is I didn't do it. Are you, as my counsel, entitled to go explore to find out where other Humvee hubcaps may have been taken?
I wish it were just that simple. Judge, and I assume your query is specifically as to the other reports and related information that were the subject of our supplemental motions for discovery. And I guess in order to properly respond to your question, we need to make the court aware that through our investigation, it is our position that the freeway shootings did not stop after the arrest of Leslie Merritt Jr. The defense is aware of very specific incidents that were clearly criminal in nature. And I'll just give the court one example, and I'm referencing our fifth supplemental motion for discovery. There's an incident that occurred on November 25th, 2015. Now, here's what we know about this case. An individual was driving on the freeway. Another vehicle pulled up to him. The other vehicle's window went down. The driver of the primary vehicle saw a bright flash coming from his periphery to his right, that other vehicle. His window then shattered. Glass went everywhere, and he felt a bullet whiz by his face. Now, fortunately, his window was down, so he didn't get another wall of glass on top of him. We've actually interviewed that individual. Okay. There was no crime scene investigation. There has been no follow-up by DPS, and effectively, DPS has deemed it non-criminal, but they never really investigated it. They never really even started an investigation. They believe, as they have in many other instances, that it's road debris or some other undetermined cause. Well, why is this relevant? Because it is our intent through these additional reports to show that the Department of Public Safety has ignored other criminal freeway shootings by either not investigating them at all or simply dismissing them as irrelevant. And why? Because now that Mr. Merritt's in custody, it would be inconvenient to their theory of the case to see that someone else is actually responsible. And I want to point out, if I may, Judge, that our requests are very narrowly tailored, sometimes by report number, sometimes specific location and time, sometimes both. It's as far from a fishing expedition as we could possibly get. We have a substantial need as part of our defense. Part of our defense is just that there are other shootings and that the Department of Public Safety has ignored them. It goes to the bias in the investigation of Mr. Merritt. We have tried with our investigators to acquire certain materials from DPS, and one of our investigators is here if you need to hear from her. She would tell the court there has been difficulties. There have been unusual delays. What she has found is that reports have been buried by investigators so that records personnel can't locate them, and that in at least one instance, clerks were specifically told by superiors not to release certain records pertaining to freeway shootings. And really our concern, Judge, is that the state is trying to pass the buck to DPS to be the unilateral gatekeeper of potentially exculpatory information. It's the state's obligation and no one else's. We don't want to see a situation where plausible deniability is enabled, effectively allowing them to be the ostrich in the sand. They have a duty to search for exculpatory information under Kiles versus Whitley. We're not sending them on a goose chase. We're not doing a fishing expedition. We're making very specific requests that fall within their ethical duty under ER 3.8. We don't believe it's appropriate, for reasons I stated in my reply, for them to pass them off to a third party. It's almost a don't ask, don't tell argument that the state doesn't want to be a part of it. But under Carpenter, of course, the police are agents of the prosecution.
Thank you. Ms. Losico. The indictment charges 4 different incidents, 2 very close in time and space. Another one on an unknown time and space. And a third known time window and a space. The link that you have is ballistics. The ballistics experts are going to talk about general characteristics and then specific characteristics. The defense thinks that your expert is wrong. Aren't they allowed to check that by determining whether there are other folks that may be similarly situated, where if those ballistic examinations were done, another connection would be made to the ones alleged in this case?
Well, Judge, I think that would be, if you look at the evidence in our case, the ballistics expert, Mr. I always say his name wrong, Kulkowski, he did not just review the ballistics found at the scenes and the vehicles against Mr. Merritt's gun. He, in fact, looked at several guns to rule those out, and then found Mr. Merritt's gun and made the comparison that those bullets found at the scenes were, in fact, from Mr. Merritt's gun. So I think that is the comparison that needs to be made. With respect to uncharged, ongoing investigations, the state does not have an obligation to provide that information because at this point it is not exculpatory. And clearly, and I haven't heard that there have been issue with the defendant obtaining the materials that they are asking for directly from DPS. I would take a very strong position that public records request law is very clear and very explicit, and it really does not allow for the hiding of documents and things of that nature. However, and this is based upon my well over a decade of experience as a prosecutor, if an investigation is ongoing, then it is not going to be released per a public records request. And that's the situation that we have here. To my knowledge, no one has been charged with, indicted, or even found to be connected with any of these shootings. And therefore, they are not relevant to the crimes that Mr. Merritt is charged with.
It becomes a unilateral decision about whether these other cases, or the caliber of the gun, the caliber of the bullet could have fired any of these shots, that there's nobody going to check that then.
Well, I believe that the police department, the Department of Public Safety, would have an obligation to, if they determined that there was some connection to another case, they would have an obligation, call it an ethical obligation, which it wouldn't be the correct term, but whatever is akin to that, into providing that information. And we don't have any information at this point to say that they haven't, they won't, et cetera, et cetera.
I agree with you that we're not here on a public records request. That's not my job. This would be a 15.1G. What interference would there be if under seal this court ordered that those cases that are listed in the defense motions that may involve the general characteristics of being the caliber bullet that the state alleged was used in these 4 instances, or the caliber of the gun, manner or type of gun that was used in these 4 instances, that those records be provided under seal to the defense counsel?
Well, Judge, I do believe that that would be feeding into a fishing expedition. Quite frankly, Your Honor, freeway shootings have been happening for years prior to the conduct that is alleged to have occurred with Mr. Merritt, and they will continue to do so. It's the same as a robbery. If House A stands next to House B, and House A gets robbed, and we have a suspect that is connected to that robbery, then allowing a defendant who has been charged with the robbery of House B to have all of the information related to House A, here we are, we're going to disclose every home invasion case that happened in a neighborhood to every defendant who is charged. It's the same thing. It would be giving credence to what is essentially a fishing expedition.
Well, I don't have everyone. I have a universe that was created by defensive. I don't know. I didn't count them 9 instances or something like that. And then I would create a smaller subset. I don't know how many of those involve a weapon similar to the one that you guys have alleged Mr. Merritt used on these 4 different occasions.
So is the court inclined to order, I can tell the court the exact type of weapon that was used, and if the court is going to limit its ruling to that, that would be over the state's objection, but I will tell the court what the gun is in order for there to be a limited ruling.
What about that type of order?
Well, here's the problem, Your Honor. In many of these instances that we are seeking in our supplemental motions, DPS didn't even conduct a criminal investigation. They didn't even...
So then what do you ask? What are you're going to get a file for a DR number that says we responded to a report. So like, not to be flip, but like a lot of burglary reports. I call the police, I need a DR number. What benefit do you get from that?
You know, the interesting thing, Judge, is, well, you know, they didn't even issue, we know in at least one of the instances that I'll proffer to you, a departmental report. They just did a simple incident, non-criminal, chalked it off. Even though on this 1125 incident, we interviewed this individual. I'm not going to call him a victim because there are no charges. So there's not an ongoing investigation.
A bullet found?
I don't know.
Well, that's, I don't know what you're asking for.
Well, that's just
except to embarrass or seek to embarrass the investigation.
No, it's not to seek to embarrass. It's to explore the bias and seek to impeach it. Were there other shootings going on? I will tell the court that there was a freeway shooting on the 202, and there was a small child in the car. And I know that investigators have resorted now, instead of bringing in crime scene techs, to taking cell phone pictures. A couple of cell phone pictures to send it to someone, and I'll say Sergeant Mapp, who's here, no disrespect to the sergeant, but I know that pictures have been sent to him, and he's making unilateral determinations. This is also an investigative process which we are entitled to challenge. And we will present expert testimony concerning shooting investigations and the proper means and protocol. And if we can illuminate the jury, there's certainly probative value that after Mr. Merritt's arrest, they're not interested in anything else. They're going through the motions and blowing it off. I think that's entirely relevant to the methodology of the investigation.
But then what do you need any particular DR to do that for?
Because we need that information. We want to meaningfully evaluate it. We don't care if it's under seal. We just want an opportunity to review it in furtherance of Mr. Merritt's defense. There's a total of 11 shootings. He's charged with 4. I really would like to know what 5 through 11 are about. They're completely separate. But, we brought up the topic of a robbery. Let's say there's armed robberies of a Circle K, and they're looking at the guys who do the money drop, the armed guards. And someone's taken into custody. And there's more that occur, and the police say, this is just random. We're not going to investigate it. That would be relevant to the defendants in the first case to say that there's more crimes going on with a similar MO, and police just really aren't following up.
So what you're asking for is not for the purpose of having your ballistic person to say, listen, this shooting not charged was done by Mr. X, and then that sort of defeats their whole linkage for their charge counts. And so it was Mr. X that did the 5 shootings, not Mr. Merritt.
Well, I think it's twofold, Your Honor. One, it's to the integrity in the investigation, the methodology. We can say that now. But until we see it, we don't know what ballistic evidence is there or was.
But then isn't that fishing?
No, it's not, because it's narrowly tailored. It's very specific. If I was asking for every shots fired call on the I-10, the 101, the 202, and the 303 for a 6-month period, that would be a pretty wide net I'd be throwing out. But what I've done is given the court very specific information: date, time, location. In some cases, an incident report number or a CAD number that we were able to acquire. This should be as simple as going to the computer and printing it up. I don't expect anyone to be going through file cabinets and searching for hours and days on end. This is a very specific request.
But it's not related to a third-party defense.
I don't know yet, Judge. It may very well be. And we've tried and we've made good faith efforts through alternative means. And we have not been successful in that regard. We tried the other way. And to the extent that it's exculpatory, we think we should have a reasonable, potentially exculpatory even, and there's a good faith basis. We should have a reasonable opportunity. This is not something we want to come out, down the line, when proceedings have already taken place. We just want the truth.
Well, among the defenses is a third-party defense. The court would grant a 15-1G, finding it relevant and necessary and not being able to be secured by other means, that among those items specifically listed, the state affirmatively do an inquiry about whether any of those incidents involve a similar caliber weapon, a similar caliber bullet, and those reports be provided under seal to defense counsel. I do believe that the defense has made a very specific inquiry, and each one of those defense requests were the that the state preserve those items. So it is ordered that those items be preserved, so if somebody later says you should have gotten them, we know what they are. Any questions, Ms. Losico?
Will you indicate in your order, Your Honor, that we are to disclose if there is a similar caliber weapon involved in any of those incidents, and you state those reports, what precisely?
Those that are listed in their 9-8 discovery requests.
The reports being the entirety of the report or the ballistics report?
The brief statement of facts so we know which incident that they're talking about, as well as any ballistic information.
Thank you.
And then that's just the first step. If it needs more, but one step at a time.
And Judge, we requested related items, 911 calls, CAD, et cetera, and we made a specific preservation.
I saw that. I'm ordering the preservation of everything that you've asked for, but I think the other part of your request of the poor investigation theory, which is a very legitimate theory, but it becomes, at that point, it's a fishing expedition. So, having done it this way, you want to take a break and look at the 9 requests and then plug in which ones my ruling has covered and which ones still need a ruling. And I know we haven't touched any of the case-specific requests. There were several case-specific requests. The easiest one, the court will grant the 9th discovery request under 15.1G. The court finds that it is not information within the control of the state, but is reasonable and necessary for the defense, so that motion is granted. I would ask counsel to confer with the source of that information to get whatever verbiage they would make them happy, and if they challenge it, I'll set a quick court date on it. So let's take a little break and let you plug in so that I can make specific orders for the clerk which of the other 8 discovery requests have been moot or granted, or they still need to be ruled on.